Our legal update today is talking about assignment provisions. And it's actually a very relevant topic for today's show because what I found is investors who are acquiring property from, sellers, homeowners, they're very good about making sure that that purchase contract is assignable. So they make sure that their assignment provisions are in there, that if they need to wholesale the contract, they can. And they basically want to be able to control that transaction and have multiple ways of, closing and whether it's, closing themselves or through another end buyer. And they're real good about that. But what they're not so good about, and I've seen this come up now multiple times, is making sure that the final documents, especially on subject to transactions or seller carry transactions, making sure that those documents, the resulting documents from the transaction, have proper assignment provisions, which give the buyer the flexibility to do a disposition of the property later on. And what I mean by that is I see where, the purchase contract is fully assignable and hopefully has language in there that says that the resulting wrap, note, and deed of trust will not have a due on sale clause. But then what happens is they go to the title company. The title company prepares their standard promissory note and deed of trust and loan or mortgage. And lo and behold, that deed of trust or mortgage has a due on sale clause. Well, now the investor has this property, and they really have one of two options to make it work, to make sure that they don't, go sideways of that due on sale clause that's now in the favor of the seller. So either you can lease the property, or if you want to sell the property, you cannot then sell it on a wrap transaction. You cannot sell it on an agreement for sale or a contract for deed. You have to sell it to a buyer who is going to come in and pay off the existing loans. Now, you can sell it on a wrap, but you run the risk that the original seller won't like that. And guess what? Now they have a remedy. Now you've allowed the seller to say, oh, no, I don't like what you did there. I don't like that you sold it to a subsequent buyer. And, now they're paying you. And then, you're paying my loan. Like, I really don't like it. We know that sellers have remorse. Well, you have a seller who has remorse, and then it's like, well, how do I get out of that? Oh, well, wait a minute. Your loan documents have a due on sale clause. And guess what? The buyer sold the property. And now you have a right to basically demand full payment of the loan or to foreclose. So you need to make sure that the resulting documents don't have that due on sale clause. And the same can be said on an agreement for sale. So you want to structure the transaction in a way that the ultimate transaction is through a contract for deed and agreement for sale. Well, does your agreement for sale or contract for deed have an alienation provision or a due on sale clause in it that would prohibit you from doing a subsequent agreement for sale, or that would prohibit you from assigning that agreement for sale to a third party? Because if it does, then once again, you're kind of stuck. You're a landlord, or you're going to sell it to an end buyer who then is going to, have to pay off the existing loans. But those are your exit strategies. You don't have the ability to potentially keep the existing loans in place and to assign that agreement for sale or to do a subsequent agreement for sale if there's a due on sale clause or an anti-assignment provision in that agreement for sale. So it's very important on your documents that you use to actually, acquire the property, the transaction documents, beyond the purchase agreement, that those give you the flexibility to, on the back end, do a proper disposition.